left. So now we will go to a case. It's going to sound somewhat similar for those watching at home. Element LLC versus the Andersons, Inc. et al. If you'd state your appearances for this case.
Yes, good morning, Your Honors. Tim Davis on behalf of the appellants, defendants below.
Good morning, Your Honor. Stan Blegan on behalf of the appellant and all appellants.
Mr. Davis, would you like to reserve any time for rebuttal? And you see we're somewhat flexible, but we've heard a lot of arguments, so hopefully we don't have to repeat everything. But would you like to reserve a little time for rebuttal?
Sure. How about 2 minutes, Your Honor?
2 minutes, so 13 and 2. That's my highest and best use as the PJ, is to keep track of the time. And obviously I did not do a very good job the first.
You might get fired, huh?
Yeah, I might get fired. That's okay.
As the timekeeper.
You may proceed.
Thank you, Your Honors. May it please the court. Judges, I have the virtue of going second. I tried to learn a few things listening to the arguments.
You might anticipate some of our questions even.
Perhaps, or maybe I'll be way off. But I do want to dive into the receivership order shortly because the panel seemed interested in that. But first, even though I appreciate you all have studied the briefs, I want to give just a tad bit of context that I think is important to examining the receivership order. Element, the plaintiff, acting through the receiver, has sued my clients, the Andersons, Inc., and its subsidiary, the Andersons Ethanol, LLC, has sued my clients under 4 agreements, expressly brought suit against them, under the operating agreement, the grain agreement, the ethanol agreement, and the feed agreement. All 4 of those contracts have broad, mandatory arbitration provisions that require arbitration of any claims, any disputes actually, related to those contracts. There really is no dispute about that. And so then the question becomes, is there anything that has happened later on that undoes or overrides or supersedes those unambiguous and broad arbitration provisions that apply here? And I think it's important as we approach that issue to bear in mind the Federal Arbitration Act, which both sides agree applies here, which commands, if there is any doubt about what should be sent to arbitration, those doubts must be resolved in favor of sending the claims to arbitration. So with that framing,
And then the arbitrator could decide whether it's appropriately there or not.
that is exactly correct, Your Honor. If there are disputes about scope, the arbitrator.
Because your case is a little bit different to the extent of the claims being made. I know there are the multiple breach of contract claims, but there are also several other claims as well that may or may not arise out of or related to the agreements. Are you saying that all of these claims would have mandatory arbitration? Is that your position?
So yes, Your Honor. Your Honor did hit the nail on the head. The scope issue and whether something is in or out is for the arbitrator to decide in the first instance. However, our position is indeed that the entirety of the receiver's complaint against my clients should be sent to arbitration. You're correct, Your Honor. There are many counts, I think 12 or 13. As I mentioned, there are at least 4 counts, 1, 3, 12, and 13, that expressly claim breach under these 4 contracts with arbitration provisions. But beyond that, Your Honor, when you boil down the receiver's complaint against my client, it's that Andy, which that's what we call the Andersons, Inc., and its subsidiary, Andy Ethanol, the Andersons Ethanol, LLC, essentially in violation of the operating agreement, used their alleged position of dominion and control to force Element to enter into the grain, ethanol, and feed agreements. And then my clients used those contracts to allegedly extract, I'll just say, millions of dollars from Element. So Judge, when you boil down the petition, it's really all about using these 3 operational contracts, the grain, ethanol, and feed agreement, to allegedly take money out of Element in violation of Andy Ethanol's duties under the operating agreement. So that was somewhat a long-winded way of saying, Your Honor, yes, we believe all of the counts that really hinge on that central allegation ought to be sent to arbitration. But again, the arbitrator can then decide scope, and if there is some question, the arbitrator gets to sort that out, and our position would be any claims that the arbitrator sends back to court ought to be stayed while arbitration continues. So to dive into this receivership order again, I think we need to approach it from the context of we have these unambiguous 4 contracts, and is there anything later on that undoes them or overrides the arbitration provision? Just start from the most general.
Let me back up a minute when we talk about the receivership, or excuse me, yes, the receivership order, which is not in our record on appeal. And I know the parties have said, yes, it's okay to take judicial notice of it, but we denied a motion to add that document to the record on appeal. So why should we take judicial notice of it?
Well, Your Honor, I think it's allowed under the Kansas statute that dictates what a court can take judicial notice of. It is an order issued by a court of this state, and so I think it's permissible for the court to take judicial notice of it. And I'm not sure if this is where Your Honor is going, but I would say, and in all candor, we said in our brief the court ought to take judicial notice of it. We agree with the other side on that, but if for some reason this court found that you cannot look at the receivership order, then our view is we win, because what's in the record are the 4 contracts with the unambiguous, broad, mandatory arbitration clauses. So again, in all candor, we took the position, and we stand by it, that the court may and should consider that receivership order. But if the panel in its wisdom finds it cannot consider that, what's in the record are the 4 contracts with arbitration clauses that without doubt apply to and cover the claims that the receiver has brought against my clients.
Can you start with section 6D of the receivership
I sure
order,
can.
please?
Yes, Your Honor. So 6D, sorry, let me get there. I think it's important to note the title of section 6 of the receivership order is third-party matters. This is on page 15. And if you look at 6D, there's an important qualifier in there in terms of what the receiver shall not be bound by, and it comes in the 4th line. And by the way, I didn't draft this receivership order. It's in the 4th line, it's contracts with third parties, right? Those are the only types of contracts, at least under 6D, that the receiver can choose to get out of, so to speak. So let's think about the contracts at issue here. The grain, ethanol, and feed agreements are contracts between Element and Andy. And so the question is Andy a third party for purposes of this receivership order? If Your Honors turn to the first page of the receivership order, it is very clear that Andy is not a third party. It is a party to the case in which this receivership order is entered, and it is defined as such. It makes no sense to say a party is a third party. And even if we indulged in that interpretation, there are reasons in the record that reveal why it just cannot be that the receiver supposedly disavowed these key contracts with the arbitration provisions, and that is because the receiver has sued us under them. Clearly, the receiver believes these contracts are still in force and are still valid. You cannot sue under a contract that you have supposedly disavowed by virtue of a receivership order. And more than that, although I don't think we need to get there, there is a provision in this 6D that talks about affirmative written ratification, and obviously the receiver acts through its counsel, and by filing a pleading in court pursuant to Rule 11, I think that, if anything, is ratification of that these contracts still exist. You can't sue for the benefits of them and simultaneously avoid your obligations.
Maybe I'm misunderstanding something, but didn't all the parties consent to the receivership?
That is correct, Your Honor.
So then if the parties consented to the receivership, why are you now objecting to the receivership acting?
Well, Your Honor, we're not,
And maybe I'm misunderstanding something here.
you're not, Your Honor. The receivership order entered in April 2023 was done, I think, technically without objection from the Andersons. But yes, we agreed to the terms of the order. A lot has happened in the underlying receivership case since that order was entered. And so I don't want to take an official position about whether or not my clients think the receivership should still be continuing today. But for purposes of answering your question, Your Honor, we're not trying to say this receivership order that we agreed to should be wiped away by this court. We're saying under the terms of it, the receiver's position that we're not allowed to exercise our contractual right under agreements that have not been undone by this receivership order. We're just disagreeing with the position that this order supposedly accomplishes that legal effect. Our position, Judge, is if you read the terms of this order, there's nothing in here that undoes or overrides the plain, unambiguous, broad arbitration agreements in the 4 key contracts at issue.
Well, the one thing that might, and we talked about it earlier in the prior case, the one thing that might is the fact that you have to, before you wouldn't have to seek leave of the court to go to arbitration. But even assuming you're correct, this receivership, which your clients in this case are parties to, unlike the prior case, does require leave of the court.
Well, Your Honor, we respectfully disagree for a couple of reasons. I think before you get to the question of must we obtain leave, you have to ask, is something that we're doing by seeking to compel arbitration prohibited by any of the subparts?
Well,
of
no,
Section
you've
15?
got to ask whether the claim against your clients is property controlled by the receivership. And if it is, then it's under the in rem jurisdiction of the district court, and so to enforce the binding arbitration, you need leave, it sounds like to me.
Well-
I mean, if we're looking at plain language,
Here's how I'd put it, Your Honor. Exclusive jurisdiction. Okay? What does that mean with respect to the district court exercising its jurisdiction? I think a plain, ordinary reading of that is at the end of the receivership process, whatever money, whatever assets are there, the district court gets to decide how those are disseminated and divvied up among the various creditors and stakeholders of the receivership. And so when you think about how...
isn't that reading something into the plain language that's not written in it?
Well, here's another way I could make the same point, Your Honor. Does exclusive jurisdiction, does that concept allow the district court to go into the parties' contracts and start rearranging their rights and obligations? Certainly we would agree, I think, I don't mean to be presumptuous, exclusive jurisdiction wouldn't give the court the right, for example, to say, I'm going to change the price of corn as set forth in the grain agreement. Well, by the same token, the court has exclusive jurisdiction over these claims in the first instance, right? The receiver has brought them before the district court where that
But the receiver could do just what you said that the district court couldn't do. The receiver is now running the company. And I'm speaking in general terms now, not necessarily this case. That's part of what a receiver does. If a receiver comes into a law firm, of course they have to go into each file and make professional judgment decisions. But here we're talking about who has the ultimate control over the property of the receivership. And that's where it seems to me that and again, the court could have granted leave. And I don't know why the court didn't grant leave, maybe, but the court didn't grant leave. And it seems like, in a way, we're putting the cart in front of the horse.
Well, let me take one more shot. at it,
Okay,
Judge.
take another stab at it.
You know, look, I think this idea of exclusive jurisdiction, the claims were brought by the receiver in front of the court where the exclusive jurisdiction lies, and then the court has the obligation to carry out and follow the contracts as they're written, right? And that's exactly what's happened here, and that's what we've asked for anyway until we submit respectfully the district court made
Well, and
error.
you may still, let's say it stays in district court. You haven't lost any arguments. The only thing you probably lost here, and I don't know why both sides would agree to some type of alternative dispute resolution, the only thing you've really lost here is the ability to save some time and some fees. Because you're going to get either, whether it's the district court makes the decision or the arbitrator makes the decision, you haven't lost any arguments here. I mean, this is all very preliminary.
You are correct, Your Honor. We have not lost anything on the merits at this point, but we submit that the right, the contractual right to go to arbitration is an important right.
Oh, I don't doubt that at all, and I think the parties ought to agree to it, but that's not my decision to
Sure.
make.
Absolutely, Your Honor, but it is an important contractual right that the FAA, the Federal Arbitration Act, says we need to lean into. We need to resolve doubts in favor of arbitration. And so as I see it, Your Honor, the claims were brought in front of the court with exclusive jurisdiction, but then the district court has the obligation to follow the contracts as they are written. And the contracts as written say we must go to arbitration. I know I can tell I'm running short on
Well,
time.
you're about 14 minutes, so I just want to make sure that they didn't have any more questions. If you want rebuttal time, you can, but go ahead and
Ma'am,
wrap this part up.
I'll just make one more point,
Sure.
Your Honor. Let's just assume we live in the world where 15B Romanet 4 applies and we need to seek the district court's leave. And while we don't agree with it, let's assume, to Judge Gardner's question earlier, that it's an abuse of discretion standard, right? As my colleague, Mr. May, articulated in his argument, let's think about the reasons that the district court gave in the transcript from the bench ruling. This notion that the operating agreement doesn't bind element, this notion that the management services agreement, overrode the arbitration clauses. I think Mr. May eloquently articulated why those arguments don't hold water. We certainly set it out in our briefs. So when those fall away, what's left? What's left is the district court is essentially saying, I have leave under the receivership order, and because I can give or deny leave, I'm going to deny leave. And that's, if we're going to apply abuse of discretion standard, I think that would fit and meet the definition of arbitrary. And as Mr. May pointed out, if we are going to rely on those other two legal bases, those are erroneous legal conclusions and inherently an abuse of discretion. So I'll close by saying, even if we get to the rubric where we're looking at, does the court have the right to deny or grant leave, and it's abuse of discretion, I think there has been an abuse of discretion. And one last interesting point that came to me when I wasn't there, the transcript of the district court, one of the counsel for the receiver actually sort of attempted to urge the district court into saying on the record, are you denying leave? And what the district court said was, no, I'm denying a motion to compel arbitration. So at least the district court didn't believe it was operating under that sort of standard. And so I really do think we are in a de novo review. Thank you, Your Honor, so much for your time.
Okay, thank you. We'll give you a little time for rebuttal. Sweet.
Good morning, Your Honors. May it please the court. So, I think everyone agrees that under Kansas law, the court has to determine if an agreement to arbitrate exists in the first instance. The de novo review discussions all have to do with if there's an agreement to arbitrate, how is it interpreted. But in this instance, this court faced with multiple and inconsistent agreements. The 4 that were cited by counsel, as well as 3 or 4 others prior to 2020.
And there are a few in the record, in the limited record we have, that do not speak to arbitration.
Absolutely. In fact, at the same time the operating agreement was executed, other contracts were executed, some with arbitration agreements, some without arbitration agreements. So there's no clear expression of the parties as to what the intent is back at that time. But even rolling forward, there's the amendment to the operating agreement, which does have the boilerplate general language that everything else is affirmed that we're not amending, but doesn't speak to arbitration. But then with an effective date of a week or 2 later in time, the management services agreement is very explicit and says all matters, all disputes will be heard in Sedgwick County. So that happened. That was the last contract between the various parties to this appeal. Then fast forward 2 years later, and you've got a receivership, and you've got, as was noted by counsel, in a negotiated receivership order that was negotiated by Andy, negotiated by Element, negotiated by the lender, presented and argued in front of the court, and agreed to its own process. And the court found, just to make sure we're all clear here, the court found it's not just denial of leave. The court found the receivership order was an agreement by Andy specifically to present all issues to the exclusive jurisdiction of that court. That was part of the court's order. And the court said also the management services agreement is a manifestation of intent to have everything heard by the court. And those two are both the latest manifestation of intent. It's an inherently factual question. That's not a de novo question. The court had available to it a great deal of briefing on that, a great deal of argument, and that court happened to be the court overseeing the receivership.
So let's ask you some real practical things here. Evidence is put into the record either by the introduction of exhibits or through testimony. not through arguments submitted in briefs or submitted orally. So when we talk about fact questions, what facts do we really have in the record other than the agreements? We don't even have the receivership, but it sounds like we can take judicial notice. We have those, and we have the judge's ruling, basically. Those are the only real evidentiary things we have in the record, aren't they?
It was not an evidentiary hearing in that evidence was offered. The judge did not take the evidence.
Right, so, but
But-
we're, as you know, a court of record. We can only go with what's in the record, and the greatest arguments in the world may be presented below, but they're not worth the paper they're written on.
But the papers themselves are evidence and facts the court can consider when making.
But those are,
a determination.
that it would be de novo. Actual reading of a written instrument is pretty clearly de novo. Where it seems like the discretion comes into play is whether or not the district court wants to grant leave in order to require arbitration. And something tells me that if the judge would have granted leave, we probably would still be here. We just would have had different colors on the briefs.
Potentially, I mean, that's obviously a situation we're not in, but the procedure and process through which motions like this are.
But what can we consider? What's really in this record being so early and no evidentiary hearing? Don't we really just have the agreements and the judge's ruling?
Well, the judge had available to it the facts that it had, that.
Well, might, but if it's de novo, you know, bless the judge's heart. You guys get do-overs here. So what I'm trying to find out is what evidence is really in this record for us to look at other than the agreements themselves, which we are in good a position to read and interpret as the district court.
Well, first, the evidence provided, the documents and exhibits, and, historical record available to the court at the time was evidence available to that court.
And that
It
was
not-
admitted into evidence,
it was
and I'd
not-
have to look back.
Pardon me. It was not formally handled as an
So
evidentiary
was
hearing,
a
but,
proffer?
but none of these would have been none of these types of proceedings, it's rare these types of proceedings are handled if a true cross-examination of witnesses.
Well, if I was
presenting
doing this at the
factual
district
evidence.
court level, I probably would have had you mark your exhibits, and hopefully you would have stipulated to the admission, or even a joint exhibit notebook. So it is often done, maybe not anymore, but that's what used to be done. But what you're telling me is there was nothing admitted into evidence.
There was no-
There was proffers made, to cut to the chase.
Yeah, there was no formal request for admission. It was all
So
presented to
should
the
we
judge.
be looking at this other stuff, or should we just focus on what actually is in the record and take judicial notice of the receivership?
Well, if these contracts are admitted and considered evidence, then all of the record is evidence, because the contracts are not formally admitted either. There was no process where an arbitration agreement was ever admitted into evidence. So if you're not going to consider any of the evidence that we're citing to in considering whether the court made a fact determination and the dueling standard applies, you can't admit the contracts either.
But we could admit the operating agreement, which I think everybody agrees that certainly at least the members are bound to regardless of whether they signed it or not.
Well, the operating agreement exists, but it was never offered into evidence.
But it's the basis of your claim.
No, it is a basis cited for certain fiduciary
Right,
duty
so it's in the
questions.
petition.
It's in, well, it's discussed in the petition.
Right, it's specifically cited. We talked about that in Mr. Geiger's argument. It's specifically cited. The breach of fiduciary duty, part of the duties that are being alleged arise out of that
Well, they're
operating
common-
agreement.
They're common law duties that are also stated in the
Right.
operating agreement.
So that operating agreement seems like that's fair game. It's part of the petition. It's part of the claim. Maybe all these other agreements aren't. The receivership, it sounds like both parties want us to take judicial notice.
Well, and I think the management services agreement, everyone agrees that was in.
It sounds like everybody agrees on that one.
Yeah, everyone agrees the receivership order.
But what I'm trying to find out, is there anything out there that you think we need to be considering?
Well, the briefing was fairly extensive on this issue, and I think anything in that briefing was accepted by the court into, not formally, but accepted into evidence and considered by the court, including the attachments to it.
And you would agree that any order that we have, which is somewhat unique here because it's basically a bench ruling, and of course on the bench we think out loud. And then all we have then is a journal entry incorporating the bench ruling. But everybody's bound by whatever the district court said on that bench ruling.
Yes. Yeah, and of course, the court has in front of it its own history in that case and knowledge of the facts that it can rely upon and consider, which it did. It, in fact, spoke to the fact that the receivership order was agreed to by Andy and by Element, the parties to the receivership order. It had those facts available to it. So all of that it relied upon in determining what the final and most recent iteration of the parties' agreement is with regard to dispute resolution, and it found the receivership order was, and if not the receivership order, the management service agreement was, and that for those reasons, it determined that there was a negative factual finding. There was no, the Andersons had not carried their burden, their summary judgment-like burden, to establish there was an agreement to arbitrate the disputes that are in front of the court. And that is itself is a failure of the Andersons to prove their case at that time. So when they come here, it's not the standard of de novo, what does this contract say, does it mean arbitration? It is their failure to prove to the court that there was an agreement to arbitrate the claims that are currently being debated here. And so therefore, the dueling standard applies to all of it. And in our you know, our position on that is that the court made that determination, found, we believe correctly, but it's not our burden to prove that, found that the agreement of the parties in the receivership order was that the court would be handling everything. There was the absent leave because it was a fairly broad order, but in that instance, this was a party to that agreement that agreed everything would be handled in court. And alternatively, the management services agreement, which had similar language that all disputes between the parties would be handled.
Now, a distinction between this case and the case we heard earlier, and there, you know, are other distinctions, but it seems like from our perspective, the primary distinction may be that in the first case, the managers were not parties to the receivership, at least were not directly parties to the receivership. Here, the appellants are parties to the receivership. Does that make any difference in our analysis?
It should not make any difference as to her decision that the latest manifestation was not the operating agreement, it was in fact the receivership order, which would obviate the operating agreement. It's the same thing, management service agreement would obviate the operating agreement. You know, as far as the issues of managers and those standards, I mean, there may be some slight differences there, but if you affirm the decision in our case that you're not going to disturb the court's factual findings and decisions under the dueling standard, then that should obviate the issues in the other.
And this was presented before the district court as a complete package. These two cases were
They were, I think.
argued together, it looks
was
like.
jointly argued the same day for efficiency. And they're, because, just similar today, because of so many overlapping arguments, it was all presented in the same, I think there's a singular transcript for both matters. I do want to address, because the court had asked about it to others. You know, one thing to note under 6D, there's all this discussion, they try to make a lot of hay with third-party question. But note, and in that same sentence, they're specifically exempting from this the security interests of the plaintiffs and Andersons with regard to other agreements. And Andersons can't say that language is irrelevant here, because if the Andersons are specifically excluded from the things the receiver has the ability to not be bound by, but then there's specific language the receiver is bound by, that kind of clarifies a bit that the third parties is not some get-out-of-jail-free card for the Andersons on that one. And I think it's already been covered, but under 15B1, which really is the operative part for the agreement of the parties for Sedgwick County District Court jurisdiction over their claims, I mean, I think the language is pretty clear there that, the language is clear there, that Anderson's is a party that would have to seek leave, or it has subjected itself to the jurisdiction It hasn't really been addressed today, but I would say the definition of commencing, prosecuting, continuing, and enforcing in any form other than this court is stretched pretty far in the appellant's argument here. I think there's no question that seeking to move a proceeding that's ongoing into an arbitration process would be certainly fit under that definition, so it's certainly something. And again, it's been discussed, but even if the court does not affirm the decision that the receivership order was the latest iteration of the party's intent with regard to arbitration, that's not the use of discretion standard, that's the dueling standard, the deferential standard. But even if that's not found, it is an abuse of discretion standard, and in this circumstance, given that the Andersons was a party to this, and the Andersons had been proceeding under this exact agreement for 2 years by the time this came up, I think there's a great deal that the judge could rely upon to exercise discretion to deny their request for leave to proceed in another proceeding. And again, I'm happy to answer any questions. I think you've heard a great deal in both of these proceedings. I think in this instance, the court's decision as to the last manifestation of intent of the parties should not be disturbed. I think it meets the deferential standard, and this matter should be remanded for further proceedings. So, thank you.
Okay, thank you, counsel. Mr. Davis, I'll give you a couple minutes here to wrap this up.
Thank you so much, Your Honor.
You're welcome.
I want to try to be clear about what happened in the district court. As Your Honors noted, no witnesses took the stand. There weren't exhibits offered into evidence. The case was decided by the district court based on the undisputed terms of written contracts that both sides agreed could be submitted to the court by way of briefing. As Your Honors have mentioned today, this court is just as capable as the district court of reading these written.
We didn't say we're just as capable. We
Well-
we have the authority. That doesn't mean we're just as capable, but we like to think we are, and we thank you for that.
That's fair point, Your Honors, and I, certainly didn't mean to discount the district court's, commendable prowess. But my point simply is this is de novo review in terms of Your Honors deciding what these written instruments mean and how they interact.
Seems like we've kind of got a mixed standard of review a little bit here. I mean, it seems like there's some things that are abuse of discretion, and then when we're interpreting the face of the contracts, then it's de novo or matter of law.
Well, in our view, the only way, in our view, that abuse of discretion might come into play is if Your Honors are looking at the introductory language to 15B about whether or not to grant leave to do certain things that are purported.
Well, don't you think we should at least look at it just to do our job? Shouldn't we look at it at least?
For sure, but that raises kind of the main point.
But even then, I think it ends up ultimately becoming an interpretation of what that means, and then whether the district court abused or didn't abuse its discretion.
Precisely, Judge, and I was looking through the record on appeal, and I want to close with this. This is transcript volume 7, page 54. The court's ruling was, quote, "The other arbitration agreement, I believe, were overruled essentially by the management services agreement, but most definitely by the agreed receivership order, which the parties negotiated and signed and in the court filed agreed to because it was agreeable to everybody." On the very next page, the Receiver's Counsel attempted to get the district court to frame its ruling as denying leave, and the court said, "No, I'm denying the motion to compel." And I think that's important because it shows the court's decision below was an interpretation of the receivership order overruling the arbitration clauses. And if you look at this receivership order, just in a general sense, it doesn't mention the word arbitration anywhere. Certainly by April 2023, arbitration was so ubiquitous, and with sophisticated counsel, if they intended to prohibit arbitration, the order would have simply said that. And then when you lay the Federal Arbitration Act on top of it, right, in terms of resolving doubts in favor of arbitration, and frankly, the entire, hour-long process here this morning, which I've enjoyed tremendously, the notion that we're having these vigorous debates about what the receivership order means and does it prohibit arbitration, at best, there's doubt. And the Federal Arbitration Act says that doubt needs to be resolved in favor of arbitration. Thank you for your time today, Your Honors.
Well, thank you all. Good arguments, and we will take this under advisement and get an opinion out to you as soon as we can.